documents.
Yes.
My Lord, ESL, if your Lordships will see, it has a slightly longer name.
Electro-steel.
That's right, my Lord. Your Lordships will notice that it is Electro Steels Limited, ESL, which is the principal borrower.
Yes.
Electro Steel Castings Limited is, my Lord, the party whom I am pursuing.
Yes.
And according to me, my Lord, it is a guarantor. And there exists, my Lord, a contract of guarantee, which can be subjected to the regime in the IBC. So, my Lord, everything really revolves around the question whether there is such a relationship as a guarantor, whether a contract of guarantee is discernible, and if it is so, then, my Lord, logically, the applications are maintainable. The NCLT, my Lord, came to the conclusion, after examining the various documents in question, that a contract of guarantee was not made out, and therefore the application was incompetent. My Lord, in the appeal before the National Company Law Appellate Tribunal, the Appellate Tribunal, my Lord, concurs with that for slightly different reasons, but, my Lord, reverses a finding and says that, in fact, there is no extinguishment of liability on account of the resolution plan, because, my Lord, various reservations are contained in a resolution plan, that this does not in any way impact or impinge upon the liability of a guarantor, liability towards a guarantor. Well, this is just the broad view which I wanted to place for your Lordship's consideration. Yes. Now, my Lord, let me place some documents, because ultimately, my Lord, under Section 126 of the Contract Act, we have to examine, my Lord, what is the law and how has it been defined. My Lord, I must say, there is a distinction which is often drawn between guarantees which are called on-demand guarantees, like, my Lord, bank guarantees, which on site you are meant to pay the money, which is guaranteed. And you also have, my Lord, what are called guarantees, which really are intended to ensure the performance of an obligation. These, my Lord, are colloquially called in English judgments as to see guarantees. That is, you ensure the performance of an obligation on whose behalf you are an obligor. So, my Lord, the expression obligor or the word guarantor, my Lord, these are all words. But ultimately, your Lordships would have to see that, is there an element of undertaking? Is there an element of voluntariness that in the event that there is a default, then this person will do what is required to remedy the situation, that that person will not be in default. So, my Lord, if the extent, if I may say so, of assistance or obligation which is undertaken by the obligor is coextensive with what was the obligation under the contract of the principal borrower, then, my Lord, it amounts to a guarantee. Now, my Lord, this is the real question which arises. My Lord, there is a recent pronouncement of this court. There was a question, my Lord, again under the IBC. There, my Lord, it was styled as a deed of hypothecation. And the court examined the question. It may be christened as a deed of hypothecation, but if it has the constituent elements of Section 126, we will not hesitate to treat it as a contract of guarantee. So, my Lord, it appears from, I'm just stating the principle, I will make it good with reference to many of these judgments, but, my Lord, it is, suffice it to say, the nomenclature, my Lord, does not really decide the issue. It is the constitutive elements of a guarantee which must be discernible, and if they are discernible, then, my Lord, notwithstanding, shall we say, a pleading, notwithstanding for the matter of fact, my Lord, something said which is inconsistent with it may not necessarily decide the issue. It is, my Lord, preponderant evidence of the presence of these elements which will lead to the existence of a contract of guarantee. Now, my Lord, that's the burden which I have to take for the purpose of succeeding in this appeal. Yes. So, my Lord, may I take your Lordships to the various documents, because I will take them in a chronological manner, and your lordships will then come to a view whether they militate against the existence of a guarantee. Well, the first document is Annexure A2, which is the sanction letter, which your lordships will find is in volume 1, your lordships printed page 204.
Yes.
So, my lord, I'm using a soft copy, but I have also noted down in the notebook, my lord.
We are old timers. We use hard copies.
That might be.
So I just add, my friend said he laid down the facts.
Oh, Mr. Mehta has vanished.
No, he'll be here. He'll be here. It is better to first note who was the debtor.
Yes.
What was the resolution plan? What did it say about the debt? Does the debt survive after the resolution plan? Because you will go to a guarantee only if the debt survives. So if it is one of our points, then once the debt is fully discharged, extinguished, there's no question whether you have or you don't have. So it may be better if you first start with the fact as to who is the debtor. My friend is an assignee of a creditor who was a part of the plan. It's better to probably look at those factors.
May I say, my lord, each one has his own rhythm.
It's okay, but
my learned friend may take it. I will
We
certainly.
are aware of those facts, Mr.
no, otherwise
you
are going straight to a guarantee without seeing what the debt is.
You're aware of the fact that he's an assignee of
So,
SREI.
Nothing is going to be missed. I assure my friend that nothing will be missed.
SREI is a short form, or the name itself is SREI?
No, my lord, it has got a slight name. SREI Infrastructure Finance Limited.
But SREI is the name by
Yes,
That's the name.
That's the name.
I thought it was a short form for something else.
So, my lord,
also IBC.
They're also in IBC.
Yeah.
My instructing attorney says that they have fortunately come out of the IBC.
Come out of it.
Yes. If they were in IBC.
Now, my lord, let me take the first document. That is page 204. This is, my lord, the foundational document, which is the sanction letter.
Yes.
And this, my lord, your lordships will notice, is addressed to the principal borrower, Electro Steels Limited.
Yes.
We write with reference to your aforementioned proposal and subsequent discussions on the subject. We are glad to convey our final approval for a rupee term loan for the above, as per the terms and conditions set out in Annexure 1, which are indicative and not exhaustive. The above facility is also subject to the terms and conditions to be enshrined in the loan agreement and other transaction documents, agreements, financing documents to be executed at a later date. Well, the reason why I'm reading this para is that as an assignee, well, ultimately I was an assignee. The assignee, in fact, assignment took place after the sanction of the resolution plan.
Yes.
And according to me, I'm a valid assignee and I have to derive my rights in terms of the underlying documents. Now, after this, if your lordships would be good enough to see further, at the bottom of this, there's a reference at printed page 207 to two annexures, Annexure 1 and Annexure 2. 207.
Yes.
Then, we now look at the annexure, which is the term sheet. Your lordships will find the term sheet printed page 208. Facility amount, rupee loan commitment, rupees 500 crores only. Your lordships will find that.
Yes.
That is, the facility which has been given by this sanction letter.
Right.
Thereafter, if your lordships will now come to the next, please come to printed page, 222.
22. Yes.
Your lordships will notice on the left-hand column, promoters, sponsors, partners, undertaking. Now, my lord, I submit with respect that as far as ECL is concerned, my lord, the person whom I am pursuing as a guarantor actually is a promoter within the definition, my lord. And this promoter, sponsors, partner shall furnish an undertaking that the promoter, sponsor shall not without the prior written approval of SREI transfer, assign, dispose of, or pledge, charge or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed prior to the date of first disbursement, to arrange for additional funds. Now, my lord, please mark item 2. To arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun, if any. Number 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. Now, my lord, according to us, this is a substantial obligation, and your lordships will find this gets strengthened and strengthened as we go along. Now, my lord, the next document which I want to place for your lordship's kind consideration is the document which is dated. My lord, this is the sanction letter. There is another document which your lordships will find is at printed page.
Do you ask for any acknowledgement of these terms or?
No, my lord, this is what they wrote. This is the first. After this, your lordship.
This is Sray's letter to electricity.
That's right. Now,
So
this is
do you
what
also ask for some
my lord, it has been
acknowledgement from them?
Yes, yes. My lord, not only that. Now, please kindly see there are further agreements.
Yes.
Let me now show, my lord. Please come to printed page 248.
Yes.
This document, my lord, begins at 247.
Yes.
Please see. This is in pursuance of our sanction letter dated 26th of July 2011, bearing reference number so-and-so, sanction letter wherein we had conveyed our approval for extending to you
Do you also have a list of dates or?
I have.
sanctions or-
I have. I'll
Yes,
hand them
sir.
over. Yes, certainly. Just get our list of the one. Okay. Get the list of this. We'll just, my lord. Please see, my lord, at page 2, printed page 247.
Yes,
This is a second letter of the
Yes.
same date.
yes.
And please see, we would like to inform you that after conducting due diligence of the project and further discussions with you, in addition to the terms and conditions set out in the sanction letter, we shall require you to provide such additional security as stipulated hereunder. And your lordships will notice at the bottom of that page, we would like to further confirm that as on date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal or corporate guarantee from Electro Steel Castings Limited is required for securing the facility. Now, my lord, this sentence, this one sentence is being, my lord, actually used, repeatedly relied upon to say that there is no corporate guarantee because of this sentence. But, my lord, really, if one reads the tense of that sentence, it says this as on date, that is, as on that date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal is required.
Who is he?
My lord, he happens to be the promoter and managing director of the group, my lord. This gentleman, Mr. Kejriwal. Or corporate guarantee from Electro Steel Castings is required for securing the facility. So, my lord, it was not a condition precedent on that date. Now, we will see how things develop thereafter to determine whether there is a guarantee. As on that date, it was not required. That's fair. But, my lord, this does not in any way, if I may say so, impinge upon documents which are executed later, actions and transactions which actually suggest that, my lord, ECL undertook its obligations like a guarantor. Now, my lord, this is the document. Now, please see, your lordships will now come to the loan agreement itself, which is at printed page, my lord, 250.
Second volume.
And in this, if your lordship will notice, this is the loan agreement. In the loan agreement, my lord, the parties are It's still, I suppose, my lord, the first volume.
Sorry, it's the second one.
I think.
Rupee loan agreement.
Yes.
Yeah.
This, my lord, is the agreement.
Yeah.
This is dated, as your lordships will see, this is also dated 26th of July, 2011. And please see, my lord, the parties are SREI and Electro Steels. Then please now come, my lord, straight away, as your lordships will see, after all the terms are properly defined,
Yes.
your lordships may kindly come to page, I'll just give my lord the printed page. This would be, yes, 386, my lord. Yes, I have that. 386.
Yes.
My lord, on this day, your lordships may also notice that ECL was having the largest percentage of shares in the principal debtor. And please now, principal borrower, promoters' undertakings. Does your lordship get that?
Yes.
At printed page 386. The promoter shall furnish an undertaking. Now, my lord, we have moved forward. Shall furnish an undertaking. The
What is
promoter.
the date of this agreement?
Well, this is also 26/11/2011.
Same day.
Yes,
Same day.
same day. 26th of July, 2011.
So everything happens on the same day.
Yes, my lord.
Yes.
The promoter shall furnish an undertaking that the promoter's sponsor shall not, without the prior written approval of SREI, transfer, assign, dispose of, or pledge, or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed in the disclosure letter. Now, my lord, this first condition, which imposes a restriction upon your ability to deal with the shares in the borrower entity, is indeed a restriction. But this restriction, my lord, is only to indicate that there is a constituent obligation which is placed upon the guarantor, well, not subject to his being called a guarantor, to arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun and or gap in means of financing, if any. 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. This, my lord, is the obligation. After this, if your lordships will kindly go over to, my lord, please see printed page. Let me show, my lord, that is clause 6.3.1. That would be, my lord, at printed page 335.
330.
Yes, I just needed to show that, my lord. That's where the obligation lies.
Who signs this document though?
I'll just indicate, my lord. My lord, only the borrower and Shrey.
Where do we find that?
My lord, we'll find that, your lordships will find. At page 466, my lord, printed page 466. It's just 416, my lord, 416.
416.
Yes, at the bottom, your lordships.
There's no signatures there. It doesn't. 416 has both ESL as well as.
Yes,
ECL.
yes, my lord. Yes.
Is that part of this agreement or is that a separate document?
That's a separate document, but I'll give you the signature page, my lord. 378, my lord.
378. Signed and accepted.
Common seal of Electro Steels Limited pursuant to the Board of Directors.
Borrower has crossed.
Yes.
Very good. Page 3.
In the presence of so and so, authorized signatory of the borrower who has signed these.
We'll continue after lunch,
Certainly.
but we'll be a little late perhaps because we have a full court meeting today. We can't tell you how long we'll be.
But
You can have a cup of coffee, extra cup of coffee before you come back.
My lord, may I please mention item number 3, my lord. We want to withdraw it, my lord. Item number 3.
Number 3.
3.
3 is passed over.
No, my lord.
Then?
The argument was heard, my lord.
And then
Senior has asked-
dismissed.
Yes, ma'am.
We want to withdraw it after the event.
Item 3.
3.
Dismiss.
Right. He doesn't want the trial to be expedited.